This is Michael Popok, Legal AF, with breaking news and some good news. The Fourth Circuit Court of Appeals, which covers South Carolina, in a three-judge panel dominated all by Democratic appointees, two by Obama and one by Biden, has ruled that at least one of the congressional maps in South Carolina was drawn by the Republican legislature in South Carolina to disenfranchise people of color, specifically African American and black voters in that district. They did so by using a test and a doctrine always used by the other side, the right-wing MAGA extremists. They used what's called the predominance test to determine, based on the legislative history and all of the facts that were developed at the trial level, that the predominant reason that the legislature in South Carolina took 30,000 black voters out of the first district, representing 62% of the black voters, and moved them to another district, was done not just to increase the Republicans' chances of holding the first district in South Carolina, but for racial prejudice reasons and racial prejudice discriminatory reasons, in violation of the U.S. Constitution's 14th Amendment and its Equal Protection Clause. That analysis avoided completely what usually founders and undermines arguments on the progressive side in favor of finding gerrymandering to be illegal. They usually try to use the Voting Rights Act that was passed in the 1960s under Lyndon Johnson. That usually trips them up in right-wing conservative circuits like the Fifth Circuit and the 11th Circuit, because the Voting Rights Act has been so watered down intentionally by the Supreme Court and the right wing of the Supreme Court, almost to make it useless in attacking when it's very obvious that racial gerrymandering, the drawing of lines of a district, has happened. So to avoid the situation, the NAACP is learning from their losses and getting better and better at what legal arguments will fly, and pulling a great panel for them in two Obama appointees and one Biden appointee to the Fourth Circuit, tried a new angle. Let's go equal protection U.S. Constitution and avoid the Voting Rights Act altogether. And that worked. What the original argument before the Fourth Circuit, was that there were three districts in South Carolina that were poisoned by and infected by racial gerrymandering. The one being the first, the other being the second district, and the other being the fifth district. Now, while the Fourth Circuit found that there was no improper racial gerrymandering in the second and fifth, they found that the predominant reason under the predominance test that the legislature redrew the map, throwing 62% of black voters out of the first, was done for racial prejudice. When you look at how the map was drawn, this is exactly why gerrymandering is called gerrymandering. It looks like a salamander. It actually looks like a tight hug of a 100-mile radius. And the only thing in common is the fact that it's diluting the black vote. It hugs I-26, between Columbia and Charleston, but there's no other thing that keeps the district together. There's no other political or common sense reason other than the fact you want to take 62% of the black voters out of a region in order to hand that over to a white Republican. And there was a real world ramification of the redrawing of the map, as the Fourth Circuit determined from the legislative history and empirical studies. What had been a competitive seat in the first, that a Democrat had actually even won in 2018, and only lost in his reelection by 2% or 1 percentage point in 2020 to a Republican. That Republican in the first, when she ran for reelection in 2020, she won the seat by 14 points. So what was once a toss-up, literally a toss-up between Democrat and Republican, And anybody's game, depending upon the quality of the candidate, could go Democrat, could go Republican, became right-wing Republican MAGA white person in the first because of these changes. And that is what got the Fourth Circuit stander up. And that's why they found a constitutional violation under equal protection. Now, the Supreme Court is going to take all this up in the next term because, or actually in this term, because they have other gerrymandering cases before it coming up from Alabama, Georgia, Louisiana, and Arkansas. Those cases are coming up under the Voting Rights Act, but they're going to have to reconcile all of these cases, the Supreme Court, and certainly the right wing of the Supreme Court, about map drawing in the face of the Constitution, equal protection, and the Voting Rights Act. The Fourth Circuit has gone one better at the present in South Carolina. They have ordered that there be no elections in the first district at all until the maps are completely redrawn and they get to see the new map by the 31st of March. So that effectively puts a stop to the first district as it currently exists. Why does all of this matter? Look at the razor-thin margin that the Republicans have in the House of Representatives. I mean, right now, it's 8 votes. If the Democrats can pick up one more vote in South Carolina, they can pick up the Santos seat in the 3rd of New York after he's hopefully impeached or removed and challenged. That's 2. Now you're down to a even slimmer margin. So these, and then the maps in Alabama, Georgia, Louisiana, and Arkansas, if they're redrawn, we could pick up another net 2 or 3 or 4. And there is the wind at the back in the sail of the Democrats going into Biden's reelection bid in 2024. Voting maps matter. Different and creative lawyering to challenge them to get around the watering down of the Voting Rights Act by the Supreme Court matter. The use of constitutional principles like the 14th Amendment and equal protection matter. And a finding by a body of judges that there has been racial discrimination and that racism is the predominant motivating factor in creating a district in a congressional map matters. And that's why this ruling by the Fourth Circuit may be the crack in the iceberg that's necessary for the Democrats and progressives to convince the Supreme Court to redraw maps off the 2020 census in time for the 2024 election. We don't like the maps now. We saw what happened by the redrawing of the maps in New York. It coughed up inadvertently or unintentionally 2 or 3 Republican seats that had never really existed in the state of New York. When you do that, when you remove seats in states that lost population that had been reliably Democratic, you add seats in places like New York to the Republican tally that had never been Republican. You gerrymander and create new Republican strongholds and dilute and disenfranchise Democratic people of color and black voters. That's how you lose the House majority. If we want to reverse all of that, you start with rulings like in the Fourth Circuit Court of Appeals. Now, is it likely that South Carolina will appeal to either a en banc full panel of the Fourth Circuit and or to the Supreme Court? Supreme Court is definitely happening. There's enough conflicting and divergent opinions of other circuits on similar issues that the Supreme Court is going to have to rule to resolve it and reconcile it. That's happening. Question is whether South Carolina is going to waste time and money to go after a potential en banc decision at the Fourth, which it may not win. My prediction is it's not going to try for the en banc. It'll stay on this decision, but take some sort of fast track or shadow docket appeal to the U.S. Supreme Court, given that the Fourth Circuit has set a very tight deadline of March 31st to redraw maps. This is Michael Popok, Legal AF, reporting on the recent success of progressive voting rights advocates to overturn a voting map because it's racially gerrymandered in violation of the U.S. Constitution in South Carolina.
Our blue wall stopped the red wave and election deniers got denied election. That's why we're celebrating with the new Democracy Prevails team. We've got lots of work to do, but we should all be proud that when democracy was tested, democracy prevailed. You've earned this. Don't wait. Get yours right now at store.meidastouch.com. That's store.meidastouch.com.